Hello, everybody, and welcome to the 2022 Intellectual Property Speaker Series presented by the MIT Technology Licensing Office and MIT Libraries. Today's session is called Commercialization of MIT Technology. I'm Deirdre Zammit, and I'll be presenting today with my colleague Lauren Foster, and I'm also here with my colleague Amelia McGowan, who's going to be one of the moderators. The seminar is being recorded and will be available online shortly. Please look at the chat for additional information about the format of this session. And we thank you for joining. And I will hand over the presentation to my colleague Lauren for us to start talking about the commercialization of MIT technology.
Excellent. Thanks, Deirdre, and welcome all. Appreciate your joining us this afternoon. My name is Lauren Foster. I'm the Associate Director of the MIT Technology Licensing Office. Just a few words about myself. I have a technical training in the life sciences, and after my doctorate, I've been pursuing various parts of my career in the private sector in intellectual property and business development in the biotech industry, and have been at MIT for the last 15 years in the very exciting role at the TLO and helping to commercialize intellectual property coming out of MIT. Deirdre, would you like to say a few words about yourself?
Sure, I'm Deirdre Zammit. I'm Associate Director of Licensing supporting physical science activity. I began my career as an engineer in the semiconductor industry and eventually transitioned into intellectual property management positions, managing patent portfolios in Lucent Technologies and Gear Systems, continuing my intellectual property career in the Naval Research Laboratory, Massachusetts General Hospital. I eventually moved into some positions in corporate venture capital and product management, market management, and transitioned again into intellectual property licensing, joining the MIT Technology Licensing Office about 4 years ago. Thank you for joining us today. We're excited to be giving this presentation.
Excellent. Next slide, Amelia, please. So the topics we're hoping to cover today, just generally starting off with an overview of university tech transfer generally, and then some specifics about MIT and our approaches to tech transfer. We'll review the intellectual property policies at MIT and how the Technology Licensing Office approaches management of IP. And then we will end off with giving some insights on how we approach commercialization of intellectual property through licensing. So the Technology Licensing Office at MIT manages all of the intellectual property arising from research at MIT, including Lincoln Labs. We work with all types of inventors, including faculty, students, trainees, and strive to build relationships with the for-profit sector, whether that be startups or established companies, to help translate MIT's technology into products that benefit society. In some instances, the distribution and commercialization of technology can be accomplished by licensing of intellectual property, and that's what we're really going to focus on largely here today. And when we speak of intellectual property, we're referring to patents and copyrights. However, we do want to note that there are other instances of very valuable assets, and technology commercialization can be achieved by access to physical or tangible embodiments of technology, such as research tools and the like. So we have a slight slant on this as thinking about patents and copyrights, but certainly are happy to entertain questions if there are other types of assets that you have questions about. Next slide, please, Amelia. So this slide is really a very generic pictorial of the tech transfer life cycle in universities with some statistics specifically from MIT. So the life cycle is often referred to as a virtuous circle. And if you really start at, I'll say due north of our compass, you'll see on the backdrop of about $1.8 billion of research funding that is spent, that was spent in fiscal year 2021. This represents the funding at both MIT's Cambridge campus as well as Lincoln Labs. That very exciting research gave rise to over 700 invention disclosures that were filed with the Technology Licensing Office. We, individual members of the licensing staff, work to evaluate these disclosures. And then where appropriate, we seek patents as a form of intellectual property protection. So on the 730 disclosures we got in fiscal year 2021, about 358 United States patents were filed. We received about over 400 issued US patents, and I believe that MIT is one of the largest single, universities in terms of receiving patents from the United States Patent and Trademark Office. And we use intellectual property to facilitate and build relationships with industry. So if we're moving down now really to due south on our circle here, once we have intellectual property, we use that as a tool to engage industry, to invest in the technology that we have developed. We do marketing and outreach to the for-profit sector, and hopefully that culminates in licenses and options, which are agreements that we complete with companies to give them the rights to practice our technology and develop products. So last fiscal year, we entered into about 140 of such commercial licenses and options. And as time goes on, our licensees work very hard to translate our technologies into products that can get commercialized. And as I said, there are sort of two types of companies that we work with, established companies and startups. Each year we do about between 20 and 30 licenses to startups. And when those our licensees are hopefully eventually successful at introducing products into the marketplace, we receive value from those licenses, economic value, which is shared with inventors as well as back into MIT, and that it goes back in the furtherance of additional research and development at the institution. So that's the virtual cycle, and those are some of the statistics from our last fiscal year. So moving on, we'll give a few comments. Next slide, please, Amelia, on the intellectual property policies of MIT. And they are somewhat representative of universities, but we are talking very much with an MIT lens here. So fundamentally, MIT's intellectual property policy stems from use of MIT funds and facilities, meaning MIT asserts ownership of intellectual property based on use of resources, facilities, and funding made available to them in the performance of research at MIT. There are exceptions to this, and they are really that the individual inventors can in fact own their own intellectual property when their research funding from MIT was not used, and when there is no significant use, as I said, of MIT funds or facilities, and that if the intellectual property was not a work for hire that was commissioned by MIT. Really, the aim of our IP policy is to make our technology available to industry for public benefit, We provide recognition to the inventors of that intellectual property through royalty sharing, which is the second point here. And really, at the end of the day, encouraging prompt and open dissemination of research results. So tech transfer is subordinate and should not hold up the open dissemination of research results, and we work very closely to ensure that the results of MIT research, even if we do pursue intellectual property protection, are made available through standard and customary routes such as publication and the like. So the MIT's royalty sharing policy, which is our mechanism of providing recognition to the inventors of commercialized intellectual property, is that after MIT takes an administration fee of 15%, we recover any outstanding patent costs that we have incurred, and then the inventors as a pool receive 1/3 of the economic benefit, and the remaining 2/3 goes back into the research enterprise at MIT. It's shared between department labs and centers and the general fund at MIT. Next slide, please, Amelia. So when researchers are thinking about grants and the like, and how to fund their research, there are some basic principles that apply to the different kinds of funding that are available to us at MIT. So we'll start with federal funding from the United States government, which still remains the vast majority of funding that is used at the backdrop of MIT research. And there are a couple of important things to understand about federal funding. The most important is that we have an ongoing obligation to notify the federal agency that is providing the funding that we have in fact received an invention disclosure. And if that invention is subject of potential patent protection, we actually have to proactively state our intention whether or not we are going to file patent protection or maintain patent protection. If we are, we let the government know, and MIT takes ownership of the patents while providing the government a limited license to use this for government purposes. And if no, MIT is obligated to waive its ownership rights back to the government agency that funded the research. So that's just a sort of a process piece that goes on behind the scenes, but really important as we evaluate invention disclosures and make decisions about patent filing. We do have obligations to continue to provide transparency to the government agencies of our decisions. Next slide, please. In addition, there are a couple of other sort of big categories of funding that are commonly used at MIT. About a little over 20% of MIT Cambridge campus research funding comes from the industrial sector or from the for-profit sector. These are really exciting opportunities for researchers to work on problems that are of interest to the for-profit sector and solve real-world problems. The basic tenets of our industrially sponsored research arrangements are, in exchange for providing the funding that gives rise to the invention, the sponsor is given certain rights in the intellectual property. And so the sponsor is always given the right non-exclusively to use the results of the research for their own internal research purposes. And then they have, as noted here, a couple of alternatives if they are interested in using our intellectual property for commercial purposes, meaning they want to use our intellectual property to develop products and services. They can either elect what is called a non-exclusive license, which is really on its face a right to use our intellectual property, but we can also give other parties the right to use the IP. That's what non-exclusive means in the terms of licensing. And that license is essentially free, and that is one of the main benefits given to a sponsor because they have funded the research. If the sponsor would like to use the intellectual property exclusively and have a sort of a competitive monopoly on the market through some level of exclusivity, those licenses are negotiated with the licensing office, and they carry revenue and royalty sharing obligations with MIT. Noting in the second bullet is fairly common in the life sciences and in other sectors is sort of research coming from nonprofit foundations, and these are often, very mission-centric organizations, and they are very interesting sources of gap funding and translational funding. They do carry, however, some intellectual property terms. There are similar, depending on the award, there can be similar obligations to inform and notify the foundation sponsor of our intent to pursue intellectual property and potentially waive rights back to them if we do not. And there are often, depending on the foundation, for example, a disease foundation such as Juvenile Diabetes Research Foundation or Cystic Fibrosis Foundation, there's often sort of a very specific intent that when we do our licensing with the commercial parties, that we put in an obligation for our licensee to address products that will treat the specific population that is the central to the mission of the foundation. So the two examples I gave, it might be that they attempt to develop products for the treatment of diabetes or cystic fibrosis. More generic foundations include foundations like the Bill and Melinda Gates, which has a much broader purview, but really very mission-centric in making products and services available to people in most need at reasonable prices. So interesting here is when people are interested in commercialization and entrepreneurship, I think the little asterisk here is, your source of funding can actually have some impacts on the intellectual property. So important to work with your tech licensing officer when you're thinking about taking certain kinds of non-federal funding to make sure that it's consistent with, or at least you understand some of the terms that come along with that funding.
Lauren, there's a question. It says, does MIT ever obtain funding from other governments?
Great question. We absolutely do. I don't know that I have the fraction, but yes, like one program where it's pretty well known is SMART, and that would be the Singapore MIT Alliance for Research and Technology, and that is, includes funding from Singapore. And so, yes, we have had, there are some international collaborations that are very closely tied to funding sources from other governments, yes.
And I would also just like to note that there are a couple other questions coming in that I will bring up later in the presentation.
Excellent. Thanks, Amelia. Can we go to the next slide, please? So right now, transitioning to sort of on our virtuous cycle, I think we're around maybe 1 to 2 o'clock. So we get our invention disclosures, and then the question is sort of, how does the technology licensing office evaluate those invention disclosures and work with our researchers to decide next steps? And these particular slides are very much focused on patent protection, because copyright protection is something that is much more straightforward. But if an invention comes in as a request that MIT file a patent, which is a pretty significant investment and on time and resources of the inventors and MIT. We really start with some fundamental questions about thinking about the technology that's described and what kinds of problems that it is trying to solve. So there is a parlance of a problem solution approach. So what problem does the technology solve? And how does it distinguish itself in the marketplace from other ways of solving this problem? And sometimes it might be that this is a problem that has yet to be solved, which is very compelling. But there are also many important sort of, we call them, incremental improvements that can lower cost of technologies, or in the life sciences may open up avenues to, treating different populations of people with disease. So we do go through that with the inventors to understand really the problem that is being addressed. How does this technology meet it? Is it disruptive, meaning brand new, sort of without really a precedent, or incremental improvements? And then, some thoughts about, if we can get a hold of it, how are companies sort of not only addressing this space now, but does the market itself perceive a need? And so if you have players in the market for this technology, are they investing in new technologies, or are they sort of happy with the technologies that exist? And then does the field really embrace external innovation and innovation coming from academia, or is it more likely these are potentially big players that reward more sort of homegrown innovation? Next slide, please, Amelia. Obviously, as I pointed out, when it's a technology that's disclosed to us for potential patent protection, we have to consider patentability considerations. So when one files for patent protection at the United States Patent Trademark Office and other patent offices around the world, there's sort of a common evaluation of the technology to see if it meets certain standards. Utility being, does it have a useful purpose? In other parts of the world, this is often called sort of industrial applicability. Is it novel? Is it new, or has someone else already done it before? And is it non-obvious? And sometimes that's called inventive step. So that's really getting at if someone else is working in a very closely related space, they have a solution that's slightly similar. Would an average person have known to sort of make the innovation that we made? Would it have been obvious to try it or obvious to do it? These are issues that we work with very closely on with our patent counsel. We have patentability analyses done by law firms that support MIT. And obviously the ability to get a patent is something we need to think about before, or likelihood of success in getting a patent, excuse me, is something we think about before going down that path. As I said, the other thing we think about is whether patents are the right way to maximize access to the technology. A patent, for those who are not familiar, is really a limited term monopoly to exclude others from practicing your invention. So when universities think about patents, our goal is not to block other people. Our goal is to say to a potential licensee, if we give you the rights to our patents, will that, and the promise of, if it's successful, that you'll have some market exclusivity and ability to make a profit, is that sort of the quid pro quo of you taking the risk to invest an enormous amount of time and resources to try to develop our technology? So it's a really interesting balance, and we use patents as really a incentive to say, we know our technology is early, we know it's high risk, if you take a chance on it and try to give it a shot and it's successful, you'll get some market exclusivity and the ability to make profits on it in the future. The other considerations that we think through very carefully when making a decision on not only patent protection, but sort of if we have copyright software, sort of what are the licensing considerations. I just gave you some examples of research awards that carry obligations. So we would check in if there were, for example, a industrial sponsor, we may check in with them and say, you have the first right to access this invention. Are you interested in intellectual property protection? And, we might collaborate with them on that. And then there are also, in our very robust ecosystem, as you know, there's a pretty high likelihood that some of our technologies will be jointly owned, arising from collaborations in all of our amazing peer institutions in Boston and quite frankly, worldwide. And so again, we just have other stakeholders that we are connecting with. If an invention is jointly owned, we would like to understand whether the institution that has other institutions that have an ownership stake, whether they have thoughts, obligations, how they'd like to approach it. So when you fill out an invention disclosure form, there's lots of questions that get asked of you about what do you think you've invented, and then a lot of administrative questions as well. And it's really to give us a head start in this evaluation and making sure as we go forward with IP protection that we're aware of all of our obligations and can position ourselves accordingly. Next slide, please, Amelia. So the patenting process at MIT is, it starts with submission of an invention disclosure. This is done on a portal and it comes to a licensing officer, as I said, for evaluation. If we typically will work with the inventors and our law firms to identify sort of the closest people working in the field and then do a patentability analysis. And based on the outcome of that, if we decide to move forward with patent protection, we use a number of law firms nationwide to support us. So all of our patents are prepared and prosecuted by external law firms. And obtaining a patent is really a negotiation with a patent office, whether it be in the United States or worldwide. And we file a document that sort of describes in a series of what are called claims what we think we've invented. And then there's a negotiation with the patent office and they compare it against, all of the relevant state of the art in your technical field, the applicable technical field. And the goal is to come down with a sort of a reasonable scope of what is, MIT in this case is entitled to claim that they have invented that is new and different from what others have described. As I said, we do hire outside law firms, but inventors are a really important part of this puzzle as the technical experts. And in the process of patent preparation, we work very closely with the inventors and are very grateful for their support on technical issues. And this is a process of obtaining a patent can take 3 to 4 years. So we do our best, but it is not an overnight process. It can take some period of time, and we follow it for time, and hopefully at the end are rewarded with intellectual property. Next slide, please, Amelia. Oh, that's our transition. This is where I'm handing it off. If folks have questions, I don't know, Amelia, are there any questions?
There are a few questions that I think are going to be covered in the next couple of slides. And then if they're not, we can come back to them at the end.
Perfect. Great. Thank you. So I will hand off to Deirdre to talk more about commercialization once we have our IP asset in hand.
Thanks, Lauren. So Amelia, if you can go to the next slide. So MIT's technology licensing philosophy is to license MIT's intellectual property for the purpose of a company developing the technology and bringing it to market. So the technology is then available to the public. And we view that if a company is successful in commercializing an MIT technology, that is also a metric for success for MIT as it relates to that intellectual property. We seek patent protection when we view it's appropriate. You might remember from the clock chart at the beginning of the presentation, we file patent applications on roughly about half of the disclosures that come into us every year. So we don't pursue patent protection on every invention that's disclosed to our office. We'll pursue patents when there's a good business case to be made for protecting the asset with intellectual property like a patent, as Lauren mentioned earlier. And one of the reasons that we do that is because for companies to make an internal business case or perhaps make a business case to potential investors that need to decide whether or not they're going to invest in like a startup, as an example, there has to be a significant business case that shows that, yes, the investment in this technology, developing the technology, moving it forward, is a good business case. And often for those business cases to be favorable, a company, whether it be a startup company or even an existing company, it helps if they have exclusive rights to the intellectual property assets. So one of the reasons that we would pursue patent protection is if we view that the way that the technology is going to get realistically commercialized through significant resource investment is by having a patent asset that we could commercially license, perhaps exclusively to a company that's committed to bringing the technology forward. And when we structure our license agreements, we do understand that depending, technologies coming out of MIT often are at early stages, but there are exceptions to that. As an example, a lot of the technologies that come out of our Lincoln laboratories are much further along in their development cycle and even have prototypes that have been field tested. So depending on the maturity of the technology and where the technology is in its development cycle, we may place different values on the intellectual property assets that we're commercially licensing, but we're fair and flexible in our licensing arrangements with companies. So, we take into consideration the technology development stage and the path to commercialization. Like, is the technology going to be licensed to a startup? Is it a technology that can easily be placed in an existing company? So these are things that we consider when we are negotiating deals with another company, with the companies, to make sure that whatever terms that we're proposing are compatible with that company's business model and makes it attractive enough for them to want to take a license to the technology and move it forward. Amelia, can you move to the next slide, please? So we're going to have a little bit of an interactive session moving forward. We're going to do a little poll here, and we want to know from you, what is your view on whether companies are eager to accept new technologies from universities? So you should see a poll question on the screen. If you could take a second and answer that question, we'd be interested to know what your thoughts are on that. Are we getting a good number of responses, Amelia? Are they still coming in?
Yeah, so it looks like they're slowing down now, so I'll end it now.
Okay, so what's the output? So it looks like 64% of us say yes, companies are eager to accept new technologies from universities. And then 36% of us are saying no. Okay, so let's go to the next slide and talk about this a little bit. So I'd say like the TLO answer to that is, well, it depends. You know, it's clearly there are companies that are very enthusiastic about commercially licensing technology from MIT and other universities. Notwithstanding, you know, MIT's technology licensing office and other comparable offices at universities understand that often the technologies that are developed in a university setting are not yet ready for commercial sales. They're not commercial ready. There are exceptions, as I mentioned earlier. You know, a lot of the technologies that come from our Lincoln laboratory are much further along in the commercialization development steps. But in general, a lot of the MIT technologies are at the discovery and basic research phase of development. And it usually is a company that will do what we have highlighted here in the middle, that applied research and that product development. Again, there's exceptions at MIT and other universities of us taking technologies further along this commercialization path. But very often it's a company that's going to have to take that basic research that's completed at a university like MIT and move it along to, you know, refine the technology and really put all the pieces together that would make it a viable technology for commercialization. And that might go even beyond just making the technology more robust. It might just, it may include things like guaranteeing a supply chain for all the components that are needed to produce the product or offer the service. And, you know, making sure that there's that really good fit between the technology and a customer demand. At MIT, you know, a lot of that is done, but it's really, you know, refining that fit between what is the technology and what problem is it addressing, and making sure that whatever solutions are being proposed are going to meet that customer's needs. So the reason we have this slide up here is to just show that the technology licensing office at MIT and in other schools does recognize that very often the technologies coming from a university are earlier stage, and there's a lot of work and heavy lifting that must occur by the companies that are taking the licenses from us to move the technology from a university environment and scale to the phases where the technology is ready for commercial sales and to offer sustainable commercial activity. Amelia, do you want to go to the next slide? Okay, we've got another question. Are the majority of MIT licenses to startup companies? So what do you think about that? Do you think most of the commercial license agreements MIT enters into are with startup companies or established companies?
Okay, answers are still coming in, so I'll give it another minute, another couple seconds.
So I see there's a question in the chat about what is different about the process used at MIT versus other universities about, you know, technology licensing and patenting. You know, I think MIT, you know, has a wonderful ecosystem for entrepreneurship. So that helps significantly with particularly startup activity. You know, so we're very fortunate to be in an ecosystem that has a lot of resources available to people that are part of the MIT community to help them, you know, assess, I've got this technology in the lab, is there a good business that can be pursued leveraging this technology to meet certain customer demands. So there's a lot of resources that really help with fostering that match between technologies and market fits. And then there's just so many other resources that are available to, aspiring entrepreneurs in the MIT community and in the greater Boston area. So I'd say that's definitely one advantage that MIT has, perhaps compared to some other universities that are not in the Boston area. So that's just, one aspect of one of the advantages we have at MIT. So Amelia, what was the answer on this one? So the answer seems to be most of us think that the majority of MIT commercial licenses are not to startup companies. Okay, so let's go to the next slide and see what the data shows. So the answer to this depends a little bit on, go back one, Amelia, thanks. It depends a little bit on whether or not we're granting commercial licenses that are exclusive or non-exclusive. So as Lauren mentioned earlier, a patent is an asset that allows the owner of that patent to block others from using the technology described in that patent. So if MIT is the owner of a patent and it grants an exclusive commercial license to a company, it's giving that company the right to exclusively practice that technology. If MIT is granting a non-exclusive commercial license to one of its patents, it's has the ability to grant additional licenses to that same patent to others. So if we look on the left at the number of exclusive commercial licenses that we've done in the past 10 years, 62% of those exclusive licenses are with startup companies. And one of the reasons we're probably seeing that is because for startup companies to attract investment and to dedicate resources in developing a technology, very often to have a positive business case that can justify the allocation of all those resources to that activity, it really does require the ability to have exclusive rights to an intellectual property asset. If we look at the non-exclusive licenses, this is granting companies the right to practice the technology, but not on an exclusive basis. You can see that, a lot of the deals that were done non-exclusively, they're with larger or more established companies. And that can be explained in part by the fact that, some established companies, they may already have a lot of other advantages in their markets, which might not require them to have exclusive rights to an MIT intellectual property asset to still get benefit from practicing the MIT intellectual property. Just think as an example, a large company, may just have a really large market share in a particular geographic region. If they're able to retain that competitive advantage for different reasons, maybe it's access to the customers or the supply chain just enables them to support that particular geographic area well, it might not be necessary that they have exclusive rights to MIT intellectual property to still retain that market advantage that they're seeing in that geographic region. So Amelia, do you want to go to the next slide?
Yeah, just quickly, there was a question about startups and exclusivity, and then I had a follow-up of, is the TLO still able to give rights to industry partners for research and development, not commercial products, if something is exclusively licensed?
Okay. Okay, so in general, MIT can offer exclusive commercial licenses to intellectual property if available. There might be, you know, the licensing office may make a decision on whether or not exclusive licensing is the optimal path for commercialization. It might make sense for some intellectual property assets to plan on non-exclusively licensing many players, because we are aware of many companies wanting rights to the same intellectual property. So, I mean, I guess one thing to mention is it depends on what the technology is and what it makes sense to do, with a focus on the technology being well developed and made commercially available. So sometimes an exclusive license path makes sense. Sometimes non-exclusive licensing may make sense. Do startups out of MIT get exclusivity? I mean, it depends whether or not it makes sense for MIT to exclusively license a technology. So that could be, you know, making a decision about a startup getting exclusive rights or a more established company getting exclusive rights. I'm not sure if I've answered all the questions.
I can jump in. I think there was a question about what are the retained rights in order. Amelia, did I get that right? That about the retained rights of a company to practice, or MIT to practice with a sponsor?
Yeah, so there was, I'm not sure that I saw that question.
Oh, okay. I'm sorry.
Sorry.
I thought I saw that. Okay.
So this is a graph showing the number of startups that have been formed over the past 20 years or so that took commercial licenses from MIT for MIT intellectual property assets. So, you know, roughly year to year, maybe about 25, 30 startups are created out of MIT that take intellectual property licenses from MIT. The maroon bar on this chart shows the number of startups that are still active over the years. So one thing that we are proud of is a lot of the startup companies that, you know, were formed quite a while ago, you know, still are in business, you know, commercializing the MIT intellectual property assets. Amelia, next slide. So, you know, when we consider, you know, whether or not the best licensing path for technology, maybe with a startup or with an established company, these are things that we're thinking about. You know, startups are often a good fit for university technology when the technology is not a technology that can just be plugged in to an existing established company. And perhaps the amount of development is so significant that, you know, it really needs to be a focused team, you know, that is a startup that's moving the technology forward. Also, technology platforms may lend themselves to be, you know, a good fit for a startup versus technologies that may be improvement technologies on established manufacturing processes of a well established industry. Also, startups tend to do well very often when some of the inventors of the technology are either involved directly in a startup or perhaps have some relationship with the startup, such as, you know, offering consulting to the startup as the startup company attempts to move the technology forward. There are many advantages of a technology being licensed to a startup company, including startups often having flexibility to pivot as needed. And that may include not just having to pivot based upon what they learn from a technical perspective, but as the markets change, perhaps modifying business plans and paths to market. Also, startups can be risky. So, it takes a certain, certain types of people that want to engage and be part of a startup company versus established companies. So, finding that mix of a good team that's eager to explore and take some risks in trying to move a technology forward from an early stage to commercialization, is a key element that we look for in, teams that we commercially license technology to, especially if it's an early stage technology. And, when we are working with startups, we do recognize that there's a significant amount of risk that they're taking on, from a technical and business perspective. And then also, we just list here, we also have to manage the avoidance of conflicts, and that relates to internal MIT policies, where if we have MIT persons that will remain at MIT but want to have some type of relationship with a startup company outside of his or her MIT responsibilities, that's just a relationship that, that person, that MIT employee will manage with certain organizations in MIT to manage the separation between his or her work at MIT and the startup company. Amelia, next slide. So when we are considering negotiating license agreements with companies, whether it be for a startup company or an established company, we recognize that there are a lot of elements that are needed within a company to successfully move a technology from the university environment to commercialization. And that includes like having the right talent in the team, and that's technical expertise, business experience, some elements of realism. And then also, we ask ourselves, will this company have the resources and assets to move the technology forward? So that's not only financial resources, but for whatever business model and technology they're pursuing, will they have the channels to market, the resources that they need to move the technology forward successfully? And also, have they considered well the match between the technology and the market demands to really ensure that the approach that they're taking to introduce the technology to market will be successful and result in long-term sustainable business activity. So Amelia, if you can go to the next slide. So very often, before we enter into a commercial license agreement, we precede that with an option agreement. And an option agreement is an agreement that allows a company the right to evaluate the MIT intellectual property, but it doesn't give the company the rights to commercially use the MIT technology during the term of the option agreement. The option agreement does provide them the right to request negotiations for a commercial license agreement with MIT. And when a company is telling us and exercising its right to negotiate a commercial license with MIT, we require that the company provide us a business plan that explains to us how they intend to commercialize the MIT technology, with what resources, with what team. And often, companies will sign an option agreement with us because they have not yet fully developed that business plan. So very often, companies will seek option agreements from us to give them some time to get a team together, raise the money that they need to, pursue next steps, and then further, like, really define the business plan for the commercialization of the technology. And the option agreement, it allows the company to do all of these things with the ability to come to us at a later date and say, we're ready to now request negotiations for the commercial license to this intellectual property. Amelia? So there are many elements of commercial license agreements, and the key elements are on this slide. In a license agreement, we will grant rights to a company, allowing the company to make, use, sell, lease, and import products and services using the intellectual property. And if we grant exclusive commercial license rights, we may also grant the ability for the company to sublicense its rights. So what that means is, if MIT exclusively licensed a technology to Company A in turn could then grant Company B and Company C rights to the same intellectual property. When we do enter into exclusive license agreements, we can be specific about what type of exclusivity, and that may mean granting exclusive rights for a particular field of use or market application. Exclusivity could also be time limited, or it could be exclusive for a particular geographic area. MIT will always retain rights, excuse me, for itself and other research institutions for teaching and educational purposes. And we will always retain rights for the US government to use the technology. And if the inventions were created with certain sponsors funding, we may need to retain rights for those sponsors to practice the inventions. Lauren, I actually have a tickle in my throat. Do you mind picking this up?
Sure, go ahead, sorry. So we're on retained rights. So we talked about reserving rights for sponsors, any sponsors of the research, including the United States government and some of the foundations that we mentioned. So one of the very mission-centric aspects of our license agreements that directly speak to our goal of having products developed to benefit society is what we call diligence. So these are basically a set of sort of development milestones staged over time that are developed, carefully with the company that specify a path towards commercialization. We understand that these are risky and they can be changed over time, but really we do ask our licensees to commit to at least trying to develop a product based on our technology. If a company does not, tries our technology and finds that it doesn't meet their needs or it doesn't work, we would very much prefer that they return the technology to us, and they have no further obligations to us. It is not in our best interest that they hold on to the technology, even though they're not developing it, and prevent others from potentially bringing that technology forward. So there are some examples here of the types of diligence that we use, but for the large number of startups that we do, there is certainly some intent to reflect things that you might not see in a license to an established company. And that would be, for example, sort of fundraising and capitalizing the companies to raise money to put towards product development, and directing some of that, certain amount of that funding towards products using the licensed technology. Deirdre, do you want to pick up on consideration?
I thank you for stepping in.
My pleasure.
So as far as consideration in a commercial license agreement, what we have listed here are some of the different types of consideration we may seek. It may include a license fee, which is a fee that's paid by the company when we enter into the license agreement. We take equity in the companies that we commercially license in cases where the companies are startup companies. We seek license maintenance fees, which are fees that are paid typically on an annual basis to keep the license active. If we are entering into exclusive commercial licenses and the company that has the exclusive license further sublicenses its rights to others, MIT will seek a share of the sublicensing income that our licensee is generating from those sublicenses. We may also have consideration passing back to MIT when our licensees have hit certain commercialization milestones. An example may be when a medical device hits a particular milestone with an FDA approval process. With that successful event, the valuation of the company typically increases. So in turn, there would be some consideration that flows back to MIT as recognition of that increased value generated as a result of the MIT intellectual property. We also seek royalties on the company's sales of product or services that utilizes the MIT intellectual property. And then if the license includes rights to patents, MIT will seek reimbursement of the patent costs MIT has incurred. So, Amelia, are there any questions that relates to anything that's on this slide?
Yes, there's a question, and it is, what is the cost structure of licensing for startups versus larger companies?
Mm-hmm. So with startups, very often, startups, want to focus their resources, including money, in the development of the technology in the early years. And we recognize that. So very often we will be a little more flexible in upfront fees that we would seek from a startup company, and then make more of the consideration coming back to MIT be in line with those successes that startup company eventually achieves, such as hitting certain commercialization milestones or the royalties on their sales. We'll also seek equity in startup companies, whereas for an established company, we're not going to seek equity in an established company. And MIT taking equity in a startup company is basically a form of deferred compensation, because we are not going to be seeking those higher upfront fees from a startup company. Okay, so when we are negotiating license agreements, we tailor the terms of the license agreement with the technology and the business plan of the company. So if we're working with a company that has a business plan that is focused entirely on providing service versus selling product, like components, we are going to tailor that license agreement around a business model focused on the company offering service. Again, from some of the earlier slides, we showed that, depending on where the technology is in its technology readiness level, there's going to be more heavy lifting by companies for some technologies compared to others. So we take that into account as well, like how much work is the company going to have to do to move the technology forward. Like we consider that in the financial terms that we define with our licensees. And as Lauren mentioned, an important element for us is to ensure that the companies are diligently pursuing the technology and will make the technology commercially available. And that's why we have very strong diligence provisions in our agreement to ensure that we have a way of checking in with the company from time to time to see how they're doing with achieving those development and commercialization milestones that they committed to when we first entered into the license agreement. We also are flexible in working with the companies that we grant licenses to. We understand that from time to time, business plans may change, business models might have to evolve. There may be market pressures that were not anticipated when agreements were first signed. So very often we certainly are agreeable to talk with our licensees, if they're experiencing situations that might not allow them to execute on the business plan that they committed to when we first entered into the license agreement. So we just want to make sure that, we have relationships with our licensees that, are two-way relationships, and we want them to succeed. So we will work with them if they are being diligent in moving the technology forward, but if they hit roadblocks along the way or speed bumps, we will work with them to try to support them in their commercialization activity. And that may include perhaps having to modify the terms of the agreement in some manner. Amelia, you can go to the next slide. So we have another question here. Are revenues from license agreements a significant source of revenue for a university? So what are your thoughts on that one? Okay, so more than half of us say no. More than half of us think that revenues from commercial license agreements are not a significant source of revenue for a university. So let's go to the next slide and see what the data shows us. Okay, so what we have here is data from about 200 US universities, where over the last 6 years, we show what the total research expenditures were for these 200 universities. And then in maroon, we show what the licensing revenue was for all 200 of these universities. And you could see in general that the amount of commercial licensing revenue that comes in from commercially licensing technologies developed at universities is about 3.5% or so compared to the total overall research budgets of the universities. So for those of you that answered 60% no, it looks like, data does suggest that it's not a significant source of revenue for the universities compared to their overall research budgets. Amelia, go to the next slide. So notwithstanding that compared to total research budgets, the amount of commercial licensing revenue is not as significant, there are many impacts and benefits to commercially licensing technology from a university, including MIT. The main focus of licensing technologies from a university to companies is to make the technology available to the public for the benefit of society. For US-based universities, a lot of research is funded by the US government. And one of the reasons the US government funds research at universities and hopes that the technology is licensed to companies that will then commercially offer the technologies is so the US government can have suppliers of products and services that the government needs. So if the government is supporting research in a particular technology area, it's probably with a focus on the government seeing a need for that technology. And then if MIT commercially licenses that technology to a company that successfully brings the technology to market, that company can then offer product to the US government for the US government needs. Another benefit of commercial licensing of university technology is creation of jobs. We mentioned, we showed in a slide that roughly about 30 startups are created every year out of MIT that take licenses from MIT. So jobs are being created with those startups. But then also we license technologies to establish companies that hire the graduate students and other researchers at MIT that worked on that technology. So licensing technology supports economic growth and job creation. Also, when we do commercial licensing, particularly with startup activity, on one of the slides we showed that, sometimes the startup companies, maybe over a certain number of years, they don't continue to operate. But the learning experience that those entrepreneurs had in creating startups is very significant and will help them in their next business endeavors, whether it be another startup company or working in more established companies as future technical and business leaders. Some other benefits relating to commercial licensing relate to the interactions a university may have with industry. Very often, if an established company is aware of a university having a particular intellectual property portfolio, that may attract so much interest in that technology that the company wants to perhaps start to work with that university and obtain commercial licenses to that technology from the university. And also perhaps that the company will want to sponsor further research in that technology space at that university. So often intellectual property attracts a lot of attention and future research interest and funding to the university. MIT has a strong reputation for commercial licensing and supporting commercial licensing to many startups that are created out of MIT. I think that can be a selling point to attract student talent in particular that may think about wanting to do a startup in the future. Like they may contemplate that coming to MIT may allow for an educational experience that may facilitate itself to allow them to create a startup company based upon work that they've done at MIT. Also, another impact of commercial licensing, Lauren mentioned earlier how the revenue that does come into MIT for commercial licensing is shared among the inventors, the MIT departments, labs, and centers, and an MIT general fund. So all of that revenue comes back into the educational system at MIT, or that goes back to the investigators that created the intellectual property in the first place. Amelia? So we have another quiz question. What is your thought on whether or not there's a quick return on investment from technology transfer from a university? So do you think there's a quick return on investment or a long return on investment from technology transfer.
Okay, before you
Okay.
get the results, I just wanted to let you know, this is out of 24 answers,
Okay. So,
so about
okay.
60%.
So answer is no, I guess. Okay, let's go to the next slide. So what we have here is an example of a MIT portfolio on high definition television technology. And this is a timeline that spans, approximately 30 years. And this shows that like the first inventions to be disclosed and then filed as patents occurred in the late 1980s, early 1990s. And significant commercial licensing revenue was generated, probably a good 10 years later. Like that's when we started to generate a lot more commercial licensing revenue. We did have some commercial licensing revenue in the early days when we first filed the initial patents, but you can see that the more significant amounts of commercial licensing revenue flowed back to MIT, a good, almost 20 years later. So at least for this technology and many technologies, that do come out of MIT, it can be many years before there's significant commercial success in companies launching to market technologies that products and services that utilize the MIT technology that are then reflected in revenue coming back to MIT. Because it's only when the companies are successful in launching their products that MIT sees the significant financial returns on MIT's commercial licensing activity. Okay, Amelia. We can go to the next slide. So that wraps up the planned slide deck. We invite you to learn more about us at our website. And there's certainly a lot of links and information on there, and you're welcome to reach out to us with any, specific inquiries that you may have. So, Amelia, would you like to go through any of the questions that look like they have not yet been answered?
Yeah, so we can start with this question. It says, approximately what percentage of startups out of MIT are in the software space versus hard physical sciences? And I actually have a chart, and it's a chart that's over time, but over time, about 21% of our startups have been in the software sector, and then hardware is our biggest one of 27%. And then if somebody has the answer to how that mix has changed over the years.
Also like, yeah, that's really great data, Amelia. I think the number of startups working in the software space is increasing over the years.
There's also a question on the topic of industry collaboration. Does MIT licensing cooperate with other academic collaborators, other institutes of higher education, or local community education?
So I'm going to answer a certain way, and I'm not sure if I'm going to answer the question the way it's intended. Just as something interesting for the audience is, very often MIT, MIT researchers collaborate with other universities and research institutions. So very often we will see invention disclosures that come in that are not created solely by, where the subject matter is not created solely by MIT investigators, but there are co-inventors from other universities. So certainly in those cases, if we have an intellectual property asset that we're considering and looking at, we will be in contact with the other schools that have investigators who are identified as being co-inventors on those technologies. So, that alone results in our office working with many universities all the time, because there are many intellectual property assets that MIT owns with other schools. Was the question really more toward like education, or is that?
I think that answers the question. I think
Okay.
it was about like other academic institutions.
Okay.
So then here's another question. It's, do you find that regulatory issues are becoming a bigger stumbling block for life science spinoffs? So if regulation is affecting the life science spinoffs more?
I mean, I can try and answer on that. I mean, as we all know, there's sort of increasing pressure on the drug industry, if that's what we mean by life sciences spinoffs. And, I do think there is a lot of pressure on pricing and making sure the drugs that get to the market are appropriately investigated and safe and the like. So anecdotally, I mean, we are not part of these companies, so we don't have any particular inside knowledge. But yes, I think as a generality, the regulatory environment is increasingly complex. And I do think that our spinoffs are required to get a lot of expertise on regulatory matters earlier and earlier in their sort of life cycle in order to navigate those, for sure. Hope that answers the question.
Okay, just looking through the questions now. There's a question, how do you articulate your efforts with the E14 fund?
I'm not familiar with them.
Okay.
I'm pretty sure that's the fund that's at the Media Lab, and we don't have any direct connections with that fund, if that's the question.
Okay. And then there's also a question, given structural inequities that lead to a lack of diversity in things like patent ownership and access to federal R&D funding, how do you work to ensure the impact the TLO has is equitable?
I think like in earlier in the presentation, Lauren highlighted the things that TLO will look at regarding, what we consider before pursuing patent protection. We base our criteria upon those things that Lauren identified. Is the technology, patentable from a legal perspective? Is the technology, does it make sense to patent the technology because patenting it will result in technology getting potentially commercially licensed? So, I mean, those are our criteria, and we really focus on those criteria. It's business case to some extent, like regarding why we will pursue patent protection.
Yeah, but diversity and sort of DEI issues are very important to us. You'll notice from our mission statement that we are striving to be inclusive, and we are certainly aware that there are underrepresented constituencies amongst inventors, that startups are woefully lacking in certain industries on having certain representation in their C-suite. So those are, as a academic institution and in an institution of higher learning, those are issues that are important to us, and we do engage in sort of ways to think about that, and try to keep ourselves accountable to ways that we can hopefully make our mission and presence known to as many people on the MIT campus as possible, and invite them to engage with us and find mentors in that may provide them with sort of a entree into activities that they may not have familiarity with because of, you know, not sort of seeing people that look like them and having them as role models. So very important question and something we care deeply about.
Okay, and it looks like there's just one more question. It is, what about state funding? That it would probably make up a small amount of money, but does the state ever provide funding to MIT through entities like the Mass Life Science Center?
So some of our startups do get funding from the state initiatives, for sure. I don't know how much of it comes directly to MIT, but as we are mentoring and helping startups, you know, navigate this wonderful ecosystem that Deirdre mentioned, those are the state resources are really important resource sort of sources of funding to help early stage companies.
I also saw a question, I think very early on about, you know, to what degree has the pandemic affected your activity, new filings, ability to license, et cetera? It actually didn't slow down for us. And maybe Lauren, maybe you want to mention some of the licensing we did supporting technologies related to COVID related technologies.
Oh, sure. Yeah, no, I answered that question in writing, but yes, we had very little impact on licensing. We did see a very small downtick in invention disclosures, but not something that sort of concerns us at the current time. Hopefully it's a one-off. But as Deirdre mentioned, I mean, we very rapidly responded with our peers from Harvard and Stanford in response to the pandemic to create a technology access framework to make any technologies of MIT that would benefit in sort of you know, managing the pandemic, treatment of COVID and the like, to make those technologies available non-exclusively, royalty-free for the duration of the pandemic via a sort of a ready-to-sign license. So we were proud of our efforts with some of our peers to make sure that our intellectual property did not stand in the way of meeting the pandemic.
Okay, well, I think we're at time. So I'd like to thank you for joining. We really enjoyed presenting to you and hope you found the information useful. And please visit our website. I know this presentation and other presentations we've made during this independent activities program period will be posted online. So be sure to go back to our website and reach out to us as you think we can help you. Thank you, everybody.
Thanks all.